You're generally aware that you must provide reasonable accommodations for your disabled employees, things like modified work duties, leaves of absence, or reduced schedules. Today, we're going to talk about something that most employers overlook.
Yes, Chris. This is the obligation to engage in the interactive process. In fact, under the Fair Employment and Housing Act, the failure to engage in the interactive process creates a whole separate legal claim.
So what is the interactive process?
It's the process by which together the employee and employer engage in dialogue and analysis regarding the employee's disability and appropriate accommodations for the disability. The EEOC has issued guidance that has been adopted by the FEHA as to the steps in this process.
Well, it's good that there's some guidance. What must employers do?
Consult with the disabled employee to identify potential accommodations and their effectiveness for performing the essential functions of the job. The employer should also consider the preference of the employee and use the accommodation that is the most appropriate for both the employee and the employer.
This is helpful, but still a little vague. What specifically would you recommend for employers?
Communication. The employer should meet with the employee in person if possible and discuss the limitations and how the job can be done with the limitations. But no matter how you do it, get the employee's feedback and come up with a plan together.
So an employer can't just impose a modified schedule on an employee without their input.
No, it's also very important for the employer to document the communications to show that they met their interactive process obligations.
As always, Jennifer, that makes sense. Thank you for joining us for Coffee Break.